Legally Speaking. With me, Tarun Nangia. There was a law in this country which had the potential to drive out all businessmen and industrialists and also make them shift out of India because they feared that law which could have wrongly prosecuted them. So this is very serious. This is a law which, I repeat, can drive off business and businessmen and also, in a sense, stop people from investing in this country. That law was Section 45 of the Prevention of Money Laundering Act. And what happened? There was a landmark judgment in the year 2017, which was argued by senior advocate Mukul Rohatgi, who had served as Attorney General. And after that, that law was held unconstitutional. The twin conditions for bail under that law were held unconstitutional by a bench which was headed by Justice Rohinton Nariman. And again, now there is some confusion on this issue because there was some amendment in the finance bill. Then what happened? There were some judgments of the high courts in various states. And now again, this matter is being heard in the Supreme Court. And in a sense, I'm very happy today that we could find time and in a sense, speak to senior advocate Mukul Rohatgi, who was kind enough to give time at a short notice. So thank you so much for joining me on Legally Speaking tonight. Now, let us now start with the 2000 landmark judgment, which I in my shows have repeated so many times, the Mikesh Tarachand Shah judgment. What was the argument that led to this landmark judgment, which did strike down this law? What was the argument?
See, Tarun, this law, in a nutshell, for your layman viewers, was a severe restriction on the grant of bail. The general law is that bail is the rule and jail is an exception. Unfortunately, since 1978, when this phrase was coined by one of our greatest judges, Justice Krishna Iyer, slowly, this has been turned on its head, and bail is no longer easy, even under the general law. And there are hundreds and thousands and lakhs of under-trial prisoners in jail who have served or are serving a couple of years, 4 years, 5 years, 6 years in jail, even as under trials. That is a horrific situation. It shows our criminal justice system in a very poor light, because there is a presumption of innocence under our criminal jurisprudence, under our constitution. And constitution is the highest law of the country. Then came along this act. And this act provided the following two restrictions on the grant of bail. And the two restrictions were, one, that the judge had to give a finding that the person who was seeking bail was innocent. And the second was that the judge had to be convinced that the person seeking bail would not commit an offense in future. For the first condition to be fulfilled, the judge has to have a trial. Trial means examination of witnesses on both sides, which takes a number of years. And bail is not a trial, and therefore no judge can give a finding without a trial as to whether a man is innocent or not. In other words, the first condition was an impossibility. For satisfaction of the second condition, the judge has to be a person who can foresee the future. Nobody can foresee the future in as much as nobody can say that if I am released on bail, I will not commit an offense tomorrow. It is an impossibility. So both these conditions were completely irrational and arbitrary. if these conditions are to be followed to the T, then nobody accused of an offense under PMLA can actually get bail. Because of this, many people were suffering, and I had the good fortune to argue this case. Both these conditions were struck down by the bench headed by Justice Nariman, struck down as being arbitrary, violative of the law, violative of the right to life, which is one of the most precious rights in the Constitution. And they were struck down. Then the next year, there was some amendment done in the Finance Act. That amendment had nothing to do with trying to bring back these conditions in a new avatar. The law is very, very clear.
Yes.
That Parliament cannot overrule a judgment of the Supreme Court as a superior appellate court over the Supreme Court. What it can nevertheless do is, it can remove the basis of a judgment. Because if the judgment points out a flaw, the Parliament can remove the flaw, thereby effectively sidestepping the judgment without overruling it. That is called a validating law. You validate something which you have done. For that, you have to remove the basis. Nothing of that sort was done by the amendment. It was not even professed to be done. The amendment does not even say that we wish to remove the basis of the judgment or we wish to have a relook at that situation. Nothing of the kind. It was a one-line amendment which was for other purposes, nothing to do with the conditions that I have just mentioned. Unfortunately, this amendment is being touted by the state and the prosecution in different cases in different states in the country and even in the Supreme Court. So we've had now a cleavage of opinion. Some courts, including the high courts, and I'm surprised, have taken the view that the twin conditions have come back. I don't know how they can come back because Parliament has no power to sit and appeal over a judgment. And Parliament has not even professed to bring it back. Yet some courts have taken this startling view. Some courts have taken the view which I am propounding, that they have not been brought back. Which means that bails must be decided in the country without reference to these two obnoxious conditions. This matter has therefore reached the Supreme Court once again. And a bench of 3 learned judges is now examining this so-called cleavage of opinion. It is examining Nikesh Tarachand's judgment. It is examining the so-called amendment. And as luck would have it, I had a chance to argue this issue before the 3-judge bench today. Some other lawyers have also done it. The case is still going on. The verdict will come maybe in a month or 2, and I hope this confusion will be resolved and Nikesh Tarachand Shah will reign supreme till something else is done. This is how and why of this issue. These are the hows and whys, and this is where we stand.
Very interestingly explained by you that the judge under section 45 has to be convinced that the person accused is innocent on the first day when he's produced for bail. So basically we are turning the presumption of innocence on its head. And then as you explained that courts, high courts of this country have in a sense wrongly interpreted the amendment brought via the Finance Act to say that section 45 has been resurrected. Now we will take that, as you said today, Justice A.M. Khanwilkar, Justice D.K. Maheshwari and Justice C.T. Ravikumar heard this matter. I would like to know for you, for all my viewers watching this, that these days we see that the CBI files a case and there have been cases that within the same day an ECIR is filed by the Enforcement Directorate. Can this happen? And secondly, if you could share with our viewers, what if he's declared innocent in a police case or a CBI case? Can the ED case go on? Because if he's innocent in the first offense, then how can he be guilty of laundering?
Well, let me tell you, you are kind of echoing what I argued today. But now let me explain. See, money laundering is a very technically defined offense. Money laundering consists of two actions combined together. The first is that there must be an offense, let us say under the IPC or under the Explosives Act or under some other law. And the second is the offense under PMLA. That is to project tainted and illegal money as untainted and legal money. Let me give you an example. Suppose somebody robs a bank. That is an offense under the Indian Penal Code, and the offense is called robbery. Suppose the person, after robbing a bank, gets 10 lakhs of rupees. From that money, let's say he buys a house and he projects and claims to the world at large that this house or a hotel, let's say a hotel, has been purchased by untainted money. So he is projecting the purchase of the hotel from untainted funds, though it came from a robbery. Therefore, the offense is of committing a robbery, which is an offense triable under the penal code by the police. But using that money to buy a hotel and projecting it as a valid and a legal purchase with legal money, projecting it to the world, inviting people to come to the hotel. So that projection of untainted money as tainted money as untainted money, that projection added to the robbery is the composite offense of money laundering. Why do you say it is laundering? When you say laundering, you send your clothes for laundry, your dry cleaning. You clean them. So typically, when you get illegal funds, you put it in a hotel or in a business and then get profits thereof to show that it is valid profits. That part, the second part, the first part is an offense of robbery, which will be tried by the criminal court under the police, usual police prosecution. But if the second part is done, in other words, if I rob a bank and just keep the money in my house, I am not projecting it. So I am guilty of robbery. I am guilty of robbery. But if I project it as untainted and buy a hotel from it and use it to earn other monies, that is projecting or claiming to the world at large, as I have indicated. So if that second part is added to the first part of robbery, then it gives rise to a distinct offense.
Yes.
This is that distinct offense which is called money laundering.
Okay.
Which consists of these two acts, robbery and projection of the robbery funds as untainted or genuine funds is money laundering, and this is defined in section 3 of the Act. Because if you say only robbery is money laundering, which can't be, then for the same offense, you are being punished by two laws. That is not possible. You will be punished for robbery by the criminal case, if you project it, you will be tried by this law, which will have another sentence, maximum of 7 years. This is how these two cases will proceed. But the importance is, as you said, if a person is acquitted or discharged, say in the robbery case,
Yes.
the court comes to the conclusion that this man was not in Delhi when this robbery took place, let us say in a bank in Connaught Place. And the second case is also going on, premised on the first. Then, under the law, the second case must fail because the bottom has been knocked out of the first case.
This is a
That
very...
is the position. That is what we are trying to tell the Supreme Court now, because there is a provision in the Act, which is explanation 1 to section 44, which runs counter to section 3. I have argued today that explanation is in the teeth of section 3, and which seeks to suggest that notwithstanding whatever may happen in the first case, that even if you are acquitted of robbery, yet the second case will go on, which is not possible. That is the position of this conundrum.
So you brought this to a very interesting argument. So basically, currently what goes on is that even if you're acquitted in the predicate offense, it's the first offense of the Delhi police.
That is the confusion in the minds of some courts. I have raised it in the Supreme Court today. I hope it will be clarified when the judgment comes.
Now, coming to kind of an analysis of how things are going on, do you think that it should have taken so many years to solve such a simple problem that it now gets to the Supreme Court? Because 2017 judgment was amply clear, wasn't it, after you argued the Nikesh Tarachand case?
See, Tarun, the point is, according to me, it was very clear. But this confusion was added by the so-called amendment.
Yes.
The confusion is added by this explanation to section 3. The confusion is added by several other provisions of an improperly drafted act. There are some other developments in the law. For example, Justice Nariman's bench has held in a case called Tufan Singh that a statement recorded before, let us say, an NDPS officer under the Narcotics Act or a customs officer, though not technically police officers, because they're not technically police officers, but they wear the hat of a police officer because they have powers of arrest. So any statement recorded by them will not be admissible in evidence, because the law is that a statement recorded of a person by a police officer, of an accused by a police officer, shall not be admissible, because the British did not trust the Indian police. So that provision continues for the last more than 100 years. And therefore, it has now been held that a special officer under an act like customs, NDPS, etc., wears a hat of a police officer and must bear the same restriction that a statement recorded before them will not be admissible. Now, there is a provision in this act called Section 50, which allows a statement to be recorded by an ED officer. And that statement will be admissible in a court. Usually what is done is statements are coerced, threatened. That is why they were made not admissible. But under this law, it is admissible. So one of the points raised by another counsel on the strength of Tufan Singh is that a statement recorded under Section 50 must be accorded the same treatment as a police officer by virtue of Tufan Singh, and a statement will not be admissible. So there are many things which have to be now worked out, some by advancement of the law, some because of imperfections in the act, and some because of this so-called confusion in the twin conditions of Section 45. So different positions are being argued by different lawyers, and that is where we are standing today.
Now, Justice N.V. Ramana, few days ago, said something to the effect that a badly drafted law can lead to a lot of unnecessary litigation that takes up the court's time. first the courts are criticized because there is pendency and all of that. But now the courts are saying that if the law is bad, then we have to unnecessarily deal with litigation, which shouldn't have come to the Supreme Court in any case. Do you think this is a classic case of that? Section 45 is a classic case of a badly drafted law.
Yeah, I entirely agree with you. I would place it higher than badly drafted. See, badly drafted is which creates a doubt, which creates a confusion. Sometimes commas are wrongly added. That's called bad drafting. 45 is not a case of bad drafting.
Then
45 is a case of a deliberate drafting, which is very, very draconian, illegal, and irrational. So there is no grammatical error. There is no other situation. It is just a situation of putting in two nasty, obnoxious provisions. A case of bad drafting is something, where you start with some object, but you reach elsewhere because of imperfect knowledge of the law, imperfect knowledge or imperfect English grammar and things like that. Sometimes a comma or a colon in a wrong place can lead to a wrong result. I would say it's a case of bad drafting. This is a case of where you knew jolly well what you were doing and you have imposed completely illegal and harsh conditions. What the Chief Justice was referring to was also a general lament, because most of the cases which come to the court also come because of this bad drafting or imperfect drafting. In fact, the Chief Justice at one time was referring to, you see, this Bihar prohibition law. What kind of law it is, what have you achieved? All the courts are clogged with this Bihar prohibition law cases in Bihar. The courts are in any case clogged. For example, some years ago, there was a lament on the fact that courts were clogged with two types of cases, lower courts. One, Motor Vehicles Act.
Yes.
Challans. Millions of challan cases.
Yes.
Where people want to contest the challan. You're not obliged to pay a challan. If you're caught on the road, you can contest it. So millions of cases are going on that. Then check bouncing cases.
Yes.
In every court, there are hundreds and thousands of check bouncing cases. The remedy is worse than the disease. It takes years and years and years. So therefore, we have to look at, it's a policy of, it has to be a policy of the government. You have to look at this and declog the courts. As it is, our judge population ratio is very poor. We have a population over 100 crores in this country. There is litigation of all types in this country, which is not there anywhere in the world. There is no such check bouncing litigation anywhere in the world. There is no such motor vehicles cases anywhere in the world. So we have to look at that and have some drastic kind of pruning or hair cutting, if I may use that phrase.
One last comment, but after you complete.
Yeah, so this is how you have to look at it. I was studying the law in Dubai. Dubai has very basic laws, if I may say so. Now, if a check bounces, man goes to the police. The police has the power to give the person whose check is bounced a few days' time. Okay, if your check is bounced, you please pay up. If you don't pay up, you go to jail. As simple as that. Now here, you can have millions of defenses. You start by saying, I never signed the check. I gave a check signed which was blank. Or I signed as a director, not as the owner. I signed it and gave it as a security, not really for transfer of goods. Any kind of, this kind of defenses. Even though there is the presumption that if you have signed a check, you jolly well knew it will create a debt. Despite that, all kinds of stupid and useless defenses are being taken, by which the court is obliged to look at that defense. You need evidence. 6-month dates are being put. So a check bouncing case can jolly well take 3 to 5 years.
Now,
then it can go in appeal. So you sign a check, it bounces, you go on merrily. Even if you have to pay more after 5 years, how does it matter? You have used that money. So these are self-defeating cases. You understand? So this has to be looked at by the policymakers. Courts can't do it. The courts have to try the cases, as per the law. It is a law which requires to be relooked at. That is why you need to have a think tank, a constant think tank as to what are the things which are ailing our system, how they can be removed. So it has to be a constant exercise, not an exercise once in 5 years. Because whatever you do in 5 years, in a few years after that, it comes back, you see.
So one last comment from you before we end the show. After that landmark judgment, Nikesh Tarachand Shah, in which you argued in Section 45 that twin condition was held unconstitutional, everybody said that businessmen will breathe easy and freely invest in India. They will not want to run away, want to take citizenship abroad of some other country as a second heaven. We see this in countries like Pakistan, where business have one foot always in some other country, be it London or US. We all know what happens there. Do you think that this kind of law can cause investment not to come to India and the existing investment to be diverted elsewhere? Do you think this is also a possibility?
I think this is also a relevant factor. This spoils or mars the investment climate in the country.
Yes.
One major reason for investment climate to be not ideal is the uncertainty of, let's say, let me give you an example. Let's say you have to give, or you give, the government gives incentives if you open a factory in a backward area. So incentives are given on electricity rates, on house tax rates, on excise payable. All these things are given as an incentive, say for 20 years. I can tell you as a rule that I have seen in the last 40 years, by and large, the period is abruptly curtailed because the government has no money. So if you have held out a solemn promise that you will get it for 20 years, you should jolly well give it for 20 years. So it is curtailed after 5 years or 10 years. That leads to litigation. Decisions are changed by departments abruptly. So how can you have a steady investment climate? A steady climate will have to be when you know the projection for 10 years. Not that things change every day. So this is the problem of not having a good climate. The second is the laws must be liberal. They must be clear. They must be stable. Courts' judgments must be stable, not changing every day. All these things add up to a restrictive atmosphere. That is the problem.
So point very well taken. Justice A.M. Khanwilkar, Justice D.K. Maheshwari and Justice C.T. Ravi Kumar, as Mr. Rodgi said, will deliver their verdict in a few weeks. I think we expect to have another Nikesh Tarachand Shah moment with your arguments. There are a lot of hopes pinned on you, Mr. Rodgi. I think the whole business community of India is watching you today, because they expect that sense will prevail. Because when we speak to industrialists, they say even we want India to become a $10 trillion economy. It can only be possible if businessmen can freely invest in this country, create greenfield capacity, create jobs, and be assured that there will be no bad law which causes them unnecessary jail terms and then they acquitted. We hope that with your arguments today in Supreme Court, sense will prevail. Thank you so much for sparing your time and joining us.
Thank you and good night.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.